SJC-12450, City of Pittsfield v. Local 447, International Brotherhood of Police Officers.
Mr. Dohoney, good morning.
Good morning. May it please the court, Richard Dohoney for the City of Pittsfield, the appellant. We are here today on an appeal from a denial from the Superior Court of the city's application to vacate an arbitrator's award pursuant to General Laws, Chapter 150C, Section 11. The core of our argument at the Superior Court level and the core of our argument here today, folks, is that the facts as found by the arbitrator, we are not looking to challenge any of the factual findings of the arbitrator, that those facts fall squarely within the edicts and requirements that this court set forward in the case of City of Boston versus Boston Police Patrolman back in the 2005 case, which is commonly known as DeShulo. That was the name of the officer. And not to be confused with a similar caption case that you folks entered about a year ago. And as you're aware, in that case, a very clear, concise public policy, I wouldn't say enacted, but was set forth that police officers who are untrue in the course of their official dealings must be, not maybe, but must be terminated.
Can I ask you about Judge Ford's decision? He clearly saw that there was some type of dancing involved in the arbitrator's decision about untrue, and he said, well, let's call it what it is, it's a lie. But I think what he also said was that there has to be some materiality involved in that misrepresentation, and here he didn't find it was material, so it didn't violate what you've said on these past cases where it's a disqualifier and the like. How do you address that?
I don't think there is a materiality requirement. What this court set forth, DeShulo, was that it be in the officer's official dealings.
So I mean, you've been in court. We've all been in court.
Sure. And
a police officer will testify that they went down a street, they stopped somewhere, and a police officer will be cross-examined, and maybe they got the wrong street name, or they got the date wrong, or they got the time wrong. These are all misrepresentations, not material, but they could be classified as misrepresentations. Certainly they are by defense counsel. Are those dischargeable offenses?
Those are not, and particularly with the examples you gave, a mistake or unintentional misrepresentation, I don't think that's been addressed, but the term used by the arbitrator and then echoed by Judge Ford is intentionally misleading. It's when you have the intent to deceive. That is a disqualifying act. And with what Judge Ford seemed to find is that because this particular lie wasn't material to the criminal case in the district court, he seemed to rely on the saying that it had to be material to the case you were prosecuting. And we totally disagree with that, Your Honor. It's the fact that you lie about anything in the course of your dealings. And in this case, we think there's a few particularly probative facts which clearly bring it into the gambit of that language that this used in the course of your official dealings. Number one, it was in a police report. As said in our brief, having a misstatement of fact in a police report, whether material or not, is a crime under Chapter 268-6A.
And it matters not that when he's asked about it for the very first time, he never testifies to it. He says, yeah, I got it out so he could be photographed.
You know, that's the argument I think you're going to hear from my brother, and that this lie isn't as bad as the lie in DeShulo. First of all, I take issue with that is he affirmatively wrote a lie, a misstatement in a police report for the purposes of covering up his own misconduct. He unlawfully, forcibly as it was found by the arbitrator, removed someone from a cruiser who was already established safely in police custody. He knew that was a violation of department policy and of law, and he wanted to cover that up. So,
is it also the department's policy to help out these stores and have the person be photographed? Or was it, I don't know, it was a policy, or was it something they did? I don't think this police officer did this on his own, or, I mean, of course he did it, but I remember reading that this is what something the police officers did to help these stores out.
There's no express policy. If there's some reference in the record to that, there may be it may be anecdotal. The key here is that police officers employed a use of force against a prisoner's will for a reason that was not permitted by policy or by law.
If we're to take the arbitrator's findings literally, and whether they seem odd, foolish, but that's how arbitration works, what do you do with the finding of the arbitrator that the questions were less than intentionally false? That in the report it is less than intentionally false. I know what Judge Ford had to say about that, but we have to apply the law of arbitration. What do we do with less than intentionally false?
I think you have to read those in context with your language in DeShulo, which is just truthful. Is it truthful or not? And if it's false, then it's not truthful. He did not tell the truth. Your Honor, we're now at our third arbitrator in the Superior Court here, kind of parsing all these words that are very similar.
Yeah, but what about he had him in a chokehold, but he didn't choke him? Our other case this year.
Well, and it was a finding of this court that what he was saying was true based on the policies as you read those terms in the Boston Police Use of Force Manual. So, I mean, obviously that's, you're jumping where I want to go with this, clearly distinguishable from Williams, where this court found that was just simply was not a lie. Here, no one, including the arbitrator, found that it was the truth. I realize that there's some troubling, maybe contradictory language that was just pointed out, but I think when you read through untrue, intentionally misleading, and cause for discipline, which is interesting that the arbitrator said it's cause for discipline, where I think, and that's just simply where the arbitrator went wrong, is this court has specified what the mandatory discipline is for that act. This arbitrator, I think, simply disagrees with this court that should be the appropriate level of discipline for this court. I don't think the arbitrator, even with that less than clause, is trying to take it out of the facts similar to DeShulo. They just simply disagree with what the result is. Our argument, obviously, is that law and public policy requires that result.
If I can turn to I know we've stated many times the standard to be applied with regard to public policy concerning an arbitrator. Yeah. And the last one, which has been quoted a number of times, essentially says, maybe literally says, the question to be answered is not whether the conduct itself violates public policy, but whether the agreement to reinstate him does so. And I'm trying to understand what that means. Is it your view that in every instance like this, a police chief must terminate the police officer?
The short answer is yes. The long answer would me parses like this in your question, Your Honor. I think when it's clearly undisputed that it's in the course of their official duties, and I think the writing of a police report is a dispositive fact in this case, Your Honor. When you decide to put lies in a police report, you could no longer be a police officer. And you know, this court has, in its prior rulings, has recited the grounds for that. It's not a hypothetical in this court, Your Honor. In your appendix at page 28, as part of this record, you have a correspondence from the district attorney from Berkshire County who would oversee this, affirmatively stating that Officer Easton is disqualified from testifying in criminal cases.
But that was not before the arbitrator. That occurred after the arbitration finding. So I understand that. So I don't know that can be. I mean, I understand your point that is a consequence or potential consequence of police perjury. But I'm trying to understand whether what this last statement says is that police chief could exercise some discretion and say, well, this may not justify it, but where the police chief comes to the view that it does require termination, then the arbitrator must uphold that. I'm just wondering whether or not there is that distinction or whether your position is no. In this situation, every police chief would have to terminate, regardless of any mitigating circumstances, any other circumstances that may arise?
The city's position is yes, they would, based on this set of facts. I don't think mitigating would be the term I would use to where maybe someone wouldn't have to be terminated. I think it would be a parsing of this in their official duties. There's not a lot of, official dealings is the term. And how you define that. I can see and probably anticipate some litigation around that. Judge Ford in our hearing went through this lying about, why you're late for work thing with us. And I think
I understand that's separate. That This is a police report. It relates to an arrest.
Yeah.
But, I mean, life's complicated. So there are mental health issues that may be involved. I just wonder whether or not this is going to, what you're asking us to do would put a police chief in a position where even when the police chief says, I think I should punish, he's been a good cop, I'm going to punish him severely for it, but there's a lot of stuff going on in that cop's life, and I don't think that this one mistake is sufficient for the employment death penalty, whether or not we'd be barring that exercise of judgment on the part of a police chief.
I think certainly in any other employment with the city or any place else, any other collective bargaining unit, that premise you just put forward would apply. But it is a privilege to be a police officer. These people compete for these positions under the agreement that they are going to be held to a higher standard ethically and legally than anyone else. A firefighter may not experience the same fate. A DPW worker wouldn't, but it is a requirement of the position that a police officer do that. And I would reference you to, I think it's pages 15 through 19 of the amicus brief filed by the Chiefs Association. That's 4 pages of string cites of civil service decisions, which I know they didn't offer as proves are binding on this court, but exemplary. This is how this is dealt with. This case is an extreme anomaly. When people submit, when police officers submit false police reports, they are terminated.
Well, let's talk about the extreme anomaly for a moment, because there's an undercurrent in the briefs and in the arbitrator's decision that this particular police officer might have been treated differently than other police officers on the force, that there might have been, and that the decision to lay off this police officer might have been related to a grievance that involving 2015 that he had with the chief of police. So the concern, this is sort of the opposite side of the coin of the Chief Justice's questions. Is there a concern that this police officer is being singled out for conduct that maybe others weren't?
First of all, I don't think you're right. There's reference to that. There's no factual basis for that whatsoever. There is no example of an arbitrator's decision or a civil service decision of another Pittsfield police officer who has been found adjudicated dishonest and was allowed to keep his job. That simply doesn't exist in the record, and nor does it exist in fact. Second of all, there was this issue raised of other violations that resulted in discipline of police officers that didn't involve truthfulness. And I think it was kind of to prey on this idea that, there's other actions that are maybe worse in the world of the human experience than this lie, but are not mandated by law to be a terminable offense. And I could make, there's one reference to an allegation of drug possession by one of the officers several years earlier. The drug was steroids. It was a very low-level crime. He admitted to it on the record, and he received the most severe punishment that the Civil Service Commission regulations allowed. And more importantly, there's reference to that in the arbitrator's decision. The arbitrator didn't make a finding that this punishment that he imposed was in response or supported by some disparate treatment to other officers. And even in that case, Your Honor, I would very simply argue that the two wrongs don't make a right. If some other officer in some other factual situation was able to evade the mandates of the Dustrul decision, it doesn't mean that Officer Easton should either.
Can I ask you about this zero tolerance part of your argument and how this works in practice?
Sure.
So if you go back to what I had asked you earlier, so a police officer testifies in a motion to suppress, and he writes in his police report that he saw a firearm in plain view in a console. Goes through a motion, and 2 passengers in the back seat say, There was no plain view. You can't see anything from that console. It happens every day in the courthouse in Massachusetts. Judge assesses credibility, hears from the police officer, hears from the witnesses, and says, you know what, I think the police officer is not credible. I don't accept what he had to say. So he's effectively saying he's lying. Does that officer get discharged?
That finding by a district or superior court judge would be evidence at a grievance hearing, whether the officer elected to go the arbitration route as we have here or go through the Civil Service Commission. That finding in of itself wouldn't be dispositive. They would then, you're right, they would probably get the termination notice, this has happened here, and then you would go through the process. And an arbrator, at that point would independently review the facts and make their determination.
Is there anything mandating that they refer it for disposition or punishment at that point? Could the chief make a discretionary call?
If it was a factual finding in a criminal case, I don't know if I could point to a mandate. Obviously, being charged with a misdemeanor or a felony, that there is a mandate at that point. A felony mandates termination. But the type of finding we find in a motion to suppress decision all the time, I can't tell you that, I can't put something in writing that would mandate that. I can tell you in practice that how it works.
Chief get to pick which officers he likes and which ones he doesn't like to recommend discharge?
No, I would argue that they do not. In every employment case I've handled for police officers in this department and the other departments I've referenced, every single time the argument is you're treating me differently than everybody else. That argument always is a great one to make to arbitrators, but no, that's not what the law provides. If a police chief has reason to believe after an internal affairs investigation that an untruth has been made in their dealings, it's our position that they're required.
In my hypothetical, if the arbitrator said, in fact, this police officer did lie about plain view, the person then, in your view, should be discharged.
You said the arbitrator did in fact lie.
Right.
Yes.
Okay, and then the issue we have in this case is whether or not that untruthfulness has to be material or not.
Well, in my view, it is material to his role as a police officer, not material to whatever criminal case may have been going on. I mean, that seemed to be where Judge Ford did hang his hat.
On the disturbing the peace.
Exactly. I would think the better analysis is it's material to the fact he was lying about to cover up his own misconduct. And this is an unusual case because oftentimes in police officer discipline cases that don't get behind arbitration is the problem is there's nothing in the police report. They simply don't reference what it is that they did that may have got them in trouble. This officer chose a totally different path to write something that was not correct, to make a lie in there. And I would argue to this court, and I hope I don't ever have to someday, is that even a conscious admission in a police report could trigger the penalties set forth in DeShulo, but that's not what we have here. We have an affirmative statement of misfact in a police report by a police officer, and I think that, as this court said, erodes the confidence in the public, and certainly puts us in a position where this particular police officer cannot be a reliable witness in a criminal trial.
Before you sit down, I'm trying to,
Okay.
the police chief's amicus says we should say public policy requires an arbitrator to uphold a dismissal where there is a material false statement in the police report. Do you disagree with their inclusion of the word material?
I disagree in that. I don't think that's what the status of the law is right now. If this court were to hold that that is the standard, I think this case still requires that the arbitrator's award be vacated and be terminated.
Because you view it to be material.
I view it to be material.
It's a long way from DeShulo. I mean, obviously, the pernicious impact of a police officer lying and having somebody lose their liberty as a result of that, I mean, there's not too many things worse than that. But the concern is that and I feel that this is part of the arbitrator's decision, or at least part of the brief, that the police chief is exercising discretion here. It's much less than DeShulo, and you got all sorts of facts going on all over the Commonwealth, like Justice Gaziano's scenario, where the police chief probably doesn't even reach the issue of whether to exercise discretion. So I guess it goes back to the initial question I have is whether or not this police officer is being singled out in some way. And you say there's nothing in the record that supports that.
That's correct. There's nothing important. There's not anything in the record or anything to my knowledge of another example of an arbitrator award finding untruthfulness in the city of Pittsfield. Answering both of your questions there is I agree that the thought of somebody being improperly convicted because of a lie in a police report is the most extreme consequence of all this. But also don't forget what happened here. Is someone who's otherwise guilty of crimes, the district attorney felt the need to dismiss the charges because he could no longer go forward and prosecute this case after it was discovered by the defense attorney. This is, I don't want to get lost in this, that somehow clearer heads prevailed and Officer Easton came forward out of good conscience. It was an industrious defense attorney who went and did their own investigation and found a videotape which directly contradicted what was written in a sworn police report and submitted to a court for prosecution. So it may not be the worst consequence, but this was a bad consequence as well as all of his misconduct, to a point where neither the chief nor the other officers can depend on this officer going forward to be part of their team and undertake their duties.
Okay, thank you. Mr. Burke, good morning.
May it please the court, here with me today is my son Jared Burke.
New generation of Burkes to take this work in time?
I try to discourage him, Your Honor, but it obviously didn't work. I have two of them.
All right.
Judge Gaziano, with regards to the question that you asked, if you look at our brief for the findings made by the arbitrator, he said, first, the grievant told the truth to investigators and at arbitration, admitting he removed the prisoner for a photograph and that it was a mistake. Second, other employees with similar misconduct received less harsh discipline or none at all. And in terms of the disparity question that you asked, Judge Lowry, this third, the chief's decision may have been affected by bad feelings about the grievant because of the June 2015 incident. This case isn't DeShulo, and it isn't Williams. What you have is a collective bargaining agreement that both parties buy into, and you select an arbitrator. And what you talked about is taking away the chief's discretion. What happens is the nuances of life are explored through the arbitration process. And if you create this bright line that they're asking for, you take away, in many ways, the discretion that we're looking for with people like yourselves, judges or arbitrators of the facts, to take the life experiences or the actual incidents surrounding this case. And if you look at it, I'm not here condoning police untruthfulness. We're a free society that depends upon their truthfulness in every situation possible. But what you said before, asking about the plain view, I was the DA. I do defense work. We both know that the judge finds them not to be credible. That doesn't constitute a blatant lie. And the question here really is materiality. And if you look at what Judge Ford said, he got it right. And he's comparing DeShulo, and that's what they argued here, is this, that any form of dishonesty or misstatement, and if it's material or otherwise, is automatically a basis for termination. And he compared DeShulo. And what he says is, quote, no such aggravating circumstances are present in the instant case. Easton did not falsely arrest Estes for shoplifting. The materiality. And his inaccurate statement in his report about his reason for removing her from his cruiser did not go to the heart of the criminal charges against her. Unlike the officer in the DeShulo case, Easton did not perpetuate his falsehood by repeating it to internal affairs investigators or by testifying falsely under oath at the arbitration hearing.
Can I ask a question about, and I understand this, the argument that this is different from DeShulo, but Just fundamentally, if you can help me understand the difference between something being untrue, intentionally misleading, but less than intentionally false. Because it sounds like, you're trying to figure out a way to or the arbitrator was trying to figure out a way to get around the fact that.
I don't want to incorporate the word dance that Judge Gaziano used, but it's clear what he looked at was the total paragraph. And if you look at the language, if he had juxtaposed and taken that sentence where it says, also the store detectives or whoever they were wanted to have her photograph taken, and taken that and put it in front as the first part of this, and then put the other down below, it creates what the real reason is. And what it is, I think what the arbitrator did, and I'm not reading his mind, but it was clear that he saw that there was an attempt to include the other component of his basis for doing what he did. And it's happening at it's a very quick situation. The woman is inside there. She's obviously out of control. She's denying any kind of responsibility for the theft. It's clear that she was there.
Yeah, no, I understand all of that, and that's not really the part that I'm focused on. I'm focused on, after all that happened, he wrote something that was false on the police report. So after he, quick action, I don't, maybe he shouldn't have, maybe it was okay, maybe. But afterwards, he wrote in his police report, I did this for the person's safety, and that part wasn't true. So this is the after reflection.
This is clearly a misstatement, however you want to phrase it, whether you want to call it something that's not intentionally false, because there's other components in what he's saying that are true. But it's clear that it's a misdirection. It's a subtle demonstration of or a means by which he's attempting to shade it in a way in the best light towards him. We don't condone it. It's clearly not a complete and accurate statement. But it does not rise to the level of, as the arbitrator found, and under the case law that's here today, under all of these type of cases where there's the three-pronged test, you have to accept what the arbitrator said, like it or not, or whether you agree with it, or you think it's erroneous, or you think that it's ill-founded. The findings that he made were that it was not an intentionally false misrepresentation. It wasn't intentionally incompletely. Maybe the better adverb is entirely false. But whether you like it or not, the law is such that under these circumstances, the absence of fraud on his part, you have that to deal with. And if you're looking at the analysis that goes further, and I think the Alaska Supreme Court case is very applicable here, because they had the same type of dishonesty, if you will. You had a trooper who's spinning his tires, creating a smoke screen, the horseplay, and he denied doing it. And the Supreme Court there used DeShulo which was cited by the government in that case. And he said, no, this isn't anything but DeShulo. And they also went further to say that there wasn't a clear and explicit or dominant basis for the trooper's termination, because it wasn't clear what the demarcation point was between levels of dishonesty. And when you talk about, I'm not saying that what he said or did was appropriate, but it's a far cry from DeShulo. And the materiality here that the court looks at under the statute does require that there be a knowing misstatement of a material matter. And that's what Judge Ford said. It's not a material issue. It doesn't mean that there isn't an overarching responsibility to tell the truth, but it's all a degree of the difference between black and white, and that's why we have arbitrations. That's why we have somebody who sits there, listens to the parties. In the same way you all have done as trial judges. You assess credibility. You take all the circumstances that are here. And there was an element of disparate treatment here, clearly. The chief was not happy with this. And to say that there was no finding of disparate treatment, that there was no evidence, you had a police officer who was assigned to the drug task force who was buying steroids. That isn't deceptive? That somehow that's not inappropriate or worse? And when they say you get the maximum, you got a 5-day suspension. If you look also at the chief's subjective ability in these type of cases to take an untruthfulness charge, and then on his own, if you look at the record, and I cross-examine him on this, so you're telling me that you have the sole ability to take a complaint of some untruthfulness and reduce it to a poor police writing discipline? And you have the subjective authority to do whatever you want. And it is those who are favored versus those who are not. And it was clear that my client was not one of the favored members of that department. There is nothing that this arbitrator did that doesn't comply with what is required of an arbitrator who's making these type of difficult decisions. And he saw that there was an effort on the part of my client to tell the truth. You know, we're all part of human frailty. We always put ourselves or our experience in the light that we want to have shining on us, so there isn't some form of criticism. There's no question he knew what he did was wrong. But the difference here is that when he's given the opportunity, he tells the truth. And this wasn't the same thing in DeShula. To think that you would,
So, I mean, the problem here, and the police chief's brief is a thoughtful one. They're saying it's extraordinarily important that a police officer tell the truth. When a police officer does not tell the truth, the value of that police officer is greatly diminished because everything the police officer testifies to becomes subject to cross-examination with regard to the willingness to tell a lie, especially on a police report. Where is the line that we say that an arbitrator cannot tolerate a police false statement? I mean, it's if you prevail, the concern will be now a police officer can lie and the arbitrator can give him 3 days on the beach, which is a very modest, considering he got 3 days on the beach before. It's a serious concern about diminishing the importance of police truthfulness.
I share that concern. I mean, I may defend police in numerous cases, but everybody should be aware of the need for truthfulness. But, you know, Your Honor, if you look at the Alaska case or the Washington State case, both of them deal with this progeny that came up from Brady versus Maryland and Giglio, that somehow that if you ever say anything wrong, you say something that's not 100% true, you're burnt for life as a police officer. And there's a recent civil service case, I think it's a Falmouth case, and but there's other cases I'm sure you're more familiar with, in which it's clear that there is an element, there's a requirement of disclosure of this internal affairs investigation, that the department is required to disclose it to the district attorney's office. The so-called Brady letters that the different district attorney's offices send out. But that doesn't in and of itself mean that that is going to become admissible evidence. There's 3 basic bases for impeachment of a police officer. And the internal affairs record does not in and of itself constitute prior bad acts that are admissible. So they're using Giglio and Brady to say the person is no longer ever going to be able to testify. And that simply does, because they have been at some element of dishonesty, doesn't make it that information admissible. And the Alaska Supreme Court pointed that out on just that, and and that was never an issue during the course of this arbitration. They didn't say that he was going to be inappropriately or unavailable or would never be able to testify in a case again. And if you even look at the the DA's letter, which was written obviously after the fact, it doesn't say that he's precluded from being a police officer. It goes on to say that he needs corroboration from another officer so that the public wouldn't be concerned that there's a conviction based solely on his testimony.
But what problems do we buy if we accept that and we say the arbitrator is right and we say that there ought to be, apart from a lie, and we can talk about whether there was a dance around those words, but apart from a lie, it has to be a material lie. Now we're having arbitrators decide the materiality of the untruthfulness, and the police chiefs would tell us, and the plaintiff would tell us, no, once there's a lie, it's over.
Well, like everything in life, there's gradations. And if you look at what the Shulo case law establishes, and I think it in and of itself is a bright line, you know, where there's testimony that goes to the heart of initiating probable cause. That didn't happen in my client's case, that there is a clear-cut basis for probable cause. The Shulo used the lie to perpetuate not just a cover-up, but to bring the criminal charges against people and then continued on with it. No one is, by applying the logic of the Shulo, as well as the requirements of the collective bargaining agreement, once people enter into that, you're not foreclosing or encouraging untruthfulness. There's still, an arbitrator can still determine, even under the collective bargaining agreement, that any kind of lie constitutes a basis for termination. It's up to the individual arbitrator. But you don't want to take away the discretion that they have. In many ways, I was thinking that the minimum mandatory drug sentences, you've all said as judges, I believe, in Superior Court. And I'm sure you've had cases come before you in which individuals were looking at a minimum mandatory because of the nature of the charge. And I'm sure there are situations where you thought, this doesn't warrant 15 years in jail, but I'm stuck with it. And it's the same thing. If you take away the element of ability to discern or to use facts or circumstances that are different in each case, then you've taken the elements of true justice out of the process. It's an imperfect world. But I don't think there's anything that you would say or do here, and the same with the Alaska Supreme Court case. If you look at it, it was a very well-written decision. And they said, you know, we may not have decided the same way that the arbitrator did. And that they made the determination that nevertheless, and they had the same kind of public policy requirements, that nevertheless, they're required and they're bound by it because that's what the parties bargained for in the collective bargaining agreement.
So if Shulo was correctly decided, and you say that this should come out differently, where is the line we draw that says you've now crossed it into public policy?
You've said it already in DeShulo. You've said it clearly. That
DeShulo has all sorts of different things. So are you saying that DeShulo is the line, or are you saying that there's another discernible line that may not have all of the aggravating misconduct in DeShulo, which crosses the line?
I think, Your Honor, if first of all, it's above my pay grade, but clearly, if there's a material misstatement under oath, that's clearly a basis for termination.
Under oath, so a police report would not be sufficient?
Well, you know, I think again, what is the degree of that? If it's a material misstatement that is made knowingly in a false manner, I don't think that in and of itself, because I don't think in and of itself that would constitute a basis for termination. It certainly could include it, but again, it's all gradation. It's all the degree of dishonesty that we're talking about. And part of
what you're describing is perjury.
Is what?
What you're describing is perjury, material false statement under oath.
True. But if you look at the Alaska Supreme Court and Washington Supreme Court wrestled with the same difficulty in terms of where that is. But they also found that because there is no clear-cut line here, it's not a dominant or well-established basis for the violation of the public policy that requires the termination.
That was going to be one of my questions, which is that's one of the first standards when you're doing an analysis with regard to the arbitration award and public policy. And so where would one find something to be well-defined and what was the other language? Well-defined and
dominant,
valid, and
explicit.
Yeah, and explicit, all those things. Where would you find it all?
Well, I think if you look at where you would find it. I mean, DeShula does give you some ideas because it goes to the very heart, the integral parts of what a police officer's responsibility are. And that's, making sure that the person is arrested with probable cause and that it's not based upon lies upon lies. And their mistakes are made, but the willingness for the person to accept their responsibility that they have made a mistake and to tell the truth when it comes up, that's something that you want to encourage. And rather than further the lie that's existing. It's not, there's no easy answer here, and I certainly don't have, a quick or glib response as to what's going to be a perfect solution. But I think the arbitration process in and of itself works very well because, looking at it, it gives the discretion to people who are earnestly trying to render a decision that's fair to all the parties.
But, Mr. Burton, I may as well ask you the question since I'm thinking it, and maybe others are. There's a lot of reluctance to put our imprimatur on any decision that involves police lying.
Sure.
And that's what's really hard about this. Even if the arbitrator's suggestions about disparate treatment and also that there was this problem in 2015 unrelated to this, I mean, it's a concern.
And imprimatur is the right word. I mean, I'm not asking you and that's what the first thing I said. I'm not here to condone untruthfulness. But there are still components of the law that we are all bound by in how these arbitration decisions have been handled prior to this. And the arbitrator's decision here is very clear. And you have to accept that. As you started out, you said, what if it's clearly erroneous or it's short of fraud? You have to start with the analysis starts with what the arbitrator found as a matter of fact here. And the matter of the fact is that based upon the elements of that paragraph, it was deceptive, it was misleading, but it was not entirely false based upon the way he had structured his argument. That's why we have people here who had life experience. And again, the word imprimatur, you're not endorsing it. If you go back to look at the Alaska Supreme Court case, they said the same thing. Don't misread this to believe that we're suggesting that there's any element of untruthfulness that we condone. You don't. You can't. But the inquiry doesn't end there. It has to be consistent with what the pre-existing law is, whether it required it, or whether there are extenuating circumstances that would justify the failure to vacate this arbitration award. And I think Judge Ford, to his credit, saw the same issues and wrestled with the same questions that you have as far as what do I do with a case that may make bad law but still is required under the factual circumstances and the pre-existing precedents that are in place now.
Would it have mattered if he had arrested her for ABPO?
Sure.
So your view is that the liberty interest, the effect on a person's liberty, may be an important factor?
I think it is. And, there was the whole claim about excessive force. He was never charged with excessive force. They used the word that she was forcibly removed. She didn't voluntarily get out of the car, but he was never charged with excessive force. But going to what the underlying questions are, is it material to the actual basis for the criminal activity that she was charged with? And there was clearly probable cause to arrest her, exclusive of anything that he said or did.
Okay, thank you.
Thank you very much.